It looks like the wheels have started coming off for Andrea Johnson and a group at the Investigative Directorate Against Corruption, IDAC. In a matter of a few days, she has been forced to make several concessions about being wrong in how they pursued senior leaders of crime intelligence. In fact, Johnson, the head of IDAC, has conceded to serious missteps, including that they acted outside their mandate when they charged these officers. She went so far as to apologize to Brigadier Mokwele, whom she accused of not being qualified for the job she was appointed to do. Not just that, she accused her of being a token appointment. But perhaps the most important question was asked by Commissioner Sesibaloyi, who wanted to know why Johnson and IDAC did this. To what end? In this episode, I asked exactly this question. Was IDAC being used to target certain people to benefit factional interests? Hello everyone, welcome back to Joe Talks Politics. I am your host, Joseph Musia. Let's get right into it. For 3 days, Johnson sat before the Madlanga Commission attempting to defend one of the most consequential investigations undertaken by IDAC. What unfolded was not simply a disagreement over legal interpretation. It was a meticulous dissection of the decisions she made, the evidence she relied upon, and the extraordinary powers she exercised. Justice Madlanga did not begin by asking whether Lt-Gen Dumisani Khumalo or Brigadier Mokwele were guilty or innocent. He began somewhere far more fundamental. He took Johnson back to the first principles of law.
For me, the grounds on which the suspicion is based is a subjective test.
I will.
No, I'm not going back on the argument.
Okay,
I'm saying in the way I've applied my mind, this is a reasonable suspicion.
Yes.
That must be borne by a reasonable man and a person, by a reasonable person who must have access to knowledge and or information that brings them to that point. If you would allow me to just take it just a moment further.
Yes.
Mr. Adams is a member of the Police Portfolio Committee. These allegations come to them from time to time. There's active engagement with the police. There are documents that are shared. There's information that is shared. I did not take his to be just the test of a subjective mind of just a reasonable man.
No. You can't obfuscate issues in the manner in which you are saying. You said you considered the test to be subjective. Now you are saying something that suggests that somehow you also considered it to be objective. You cannot have it both ways. Please, Advocate Johnson. Let me ask you the question again. Did you consider the test to be subjective?
Correct.
Now, what are you saying? You've just said something that seems to suggest that you also considered it to be objective. Make me understand what you are saying.
Maybe I didn't express myself correctly. I'm saying that the reasonable man test, the person test, applies. But
once you see, therein lies the problem. Once you say that the test is subjective, then you look to what was going on in a specific person's mind. That's subjective. It has nothing to do with a reasonable person. That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot. I mean, even a law student doing first year would know that at a later stage during their first year of legal studies. In fact, across the board within legal studies, you go to your law of delict, you go to even criminal law, your culpable homicide, you encounter the reasonable test across the board. So how you could mix the subjective test and the objective test completely escapes me. So back to my question, you have said you accept, or rather you say the test under Section 27 is a subjective test. Do you stand by that? Because if you do, it raises very serious issues about your application of the section yes. Over all these years. Are you sticking to your assertion that the test is subjective, even though it uses reasonable? Once you have reasonable, that leads to the objective test. You should know that. Yes. Are you insisting that the test is subjective?
It is an objective test of the reasonable person.
It's an objective test.
For an advocate with 30-odd years of experience behind her name, this was some takedown. Those questions became the thread running through Johnson's entire testimony. Again and again, the commissioners challenged the logical foundations of IDAC's investigation. Again and again, Johnson was forced to concede errors in judgment, shortcomings in her decision-making, and in some instances, that there was simply no factual basis for assertions that found their way into court papers. Perhaps nowhere was this more striking than in the case of Brigadier Mokwele. Remember, Mokwele and Crime Intelligence Head General Khumalo, among others, are currently in court accused of hiring Mokwele irregularly in pursuit of capturing crime intelligence. They face 4 counts of fraud and corruption arising from that appointment. Is there anything more damaging to a person's professional standing? Listen to this interaction between Commissioner Sandile Khumalo and Johnson regarding Mokwele's appointment.
I don't know her qualifications, but the fact that you point me to that means they must be there.
Stop there, Advocate Johnson. You don't know her qualifications.
I know she has, it was called megatronics.
Do you know what her qualifications are?
Not all her qualifications, no.
So why do you make a statement under oath to say she's not suitable for this position if you don't know what her qualifications are? Why do you make a statement to this commission to say the big picture will show that she doesn't have qualifications? Can I ask that they be flighted so that we can look at them? Can we go to 270 on the same file? Are you there?
Yes.
So that's a degree in engineering, industrial engineering. Do you see that?
I see that.
So already she meets the qualification. Now go to the next page on 271.
I see that.
Are you there?
I am there.
Now that's a diploma in mecha, not mega, mechatronics. Now what is the relevance of that? That is the core description of this role. If you go back to the advert on 176, you will see that the core functions, what crime intelligence was looking for, is exactly this qualification. Because the description of the role tells you that they want somebody who's qualified in mechanics and electronics and all of those. Do you see those?
I see that,
Yes.
Commissioner.
Now, from 270, I don't want to show her matric certificate.
No,
it's not
yes.
fair to Ms. Mokwele, but it's on 272. Please don't flight it. It's quite clear that this is somebody who is very bright. I must say this to you. Before I saw these files, the picture painted in my head was that crime intelligence appointed a receptionist from BMW. That's the picture I had in my head. Until I saw these files, then it became clear to me that this person is not just qualified, but her qualification exceeds the requirements. In her application for this position, she lists all those. She goes further and she says, I'm studying for my MBA. Are you aware of that?
No, I haven't gone through her affidavit.
Did you see her application for this job?
No.
Now, if you have not seen her application for this job, how can you make a recommendation, as you did in your prosecution memo, that she must be charged with fraud and this many other things? What fraud has she committed? According to the investigation, let's not go to what the court will decide.
Yes.
I don't want to get into what the charge sheet says.
Yes.
We limit ourselves to investigation that leads to arrests and charges. What
Correct.
fraud has Ms. Mokwele committed that justifies you recommending to the DPP that she must be charged with fraud and state capture and all of those things?
Again, I relied on the briefing from my team, and it's going to go back to what counsel had asked me, that I trusted them implicitly. I now see that the facts as I may have received them then, and I'd have to go back and look at it, were incorrect.
I'm going to challenge you before we go to, you described Ms. Mokwele's appointment as a token appointment. It's an unfair statement to make, having not seen her CV, having not seen her qualifications. Can you please, in this commission, withdraw the statement that her appointment is a token appointment? It is an insulting thing to say.
I would have to go further than to withdraw. I would have to apologize that that statement was made.
Because it's one thing to say an appointment is irregular.
Yes.
It's quite another to say it's a token appointment.
Yes. I base it on what I was given, but I accept, having gone through this file, that the word unsuitable is unsuitable, and that the word token is wholly inappropriate.
This is the head of South Africa's foremost anti-corruption body. She and her entourage of highly paid investigators could not simply ask Mokwele for her qualifications. In the short period of its existence, the Commission not only found the qualifications but also verified with SAPS that the selection process met all the requirements. According to Section 27 of the NPA Act, Fadil Adams was supposed to refer suspected corruption or other specified offences directly to IDAC by submitting an affidavit. It is the legal gateway through which IDAC acquires a matter for assessment. If the head of IDAC is satisfied that there are reasonable grounds to suspect a specified offence, the matter can be authorized for investigation. Instead of that process unfolding, this is what actually happened.
My question is, that document you're holding in your hand, IDAC solicited it from Mr. Adams. You received a letter from the minister. You then directed Mr. Perumal to act on that and contact Mr. Adams and
Ask him for his...
Ask him. So you solicited a Section 27 affidavit from a would-be complainant.
I don't agree with the solicited.
Ma'am?
I don't agree with solicited. We would have asked him. Because, you see, I'm going into the detail that's not mine and not in my head, and I don't want to sound like I...
It's yours, Advocate Johnson. You are the one who gave an instruction to Chief Perumal to contact Mr. Adams. So Ms. Sillo's question relates to that. That has nothing to do. Mr. Perumal would then have been the actor on your instruction. That's where the question is. It has nothing to do with what Mr. Perumal then did down the line. So please do not deflect the question and refer to what Mr. Perumal would have done or not done. Can you please respond to the question?
Then we would have obtained the statement.
At your instance, that's the substance of the question.
That is correct.
That's what Ms. Sillo means when she says to you, so you solicited the affidavit, because what came out of your instruction that please contact Mr. Adams was the submission of the Section 27 affidavit. So it's on that basis that Ms. Sillo is suggesting to you, you solicited that affidavit. Do you now agree?
I agree.
As you sit here today, is that appropriate of IDAC to be soliciting complaints from members of the public on the basis of which then IDAC initiates investigations?
No, we're not supposed to solicit.
This brings us to perhaps the most pertinent question asked by anyone so far. Forget the missteps. Forget the concessions and apologies. What is behind these actions?
You should not think that the fact that there's a review process, there's a representation process, and therefore what you sought to do, which is to prosecute, if those decisions are reversed, then all is good. It cannot be that. Our inquiry is really about why did you make these decisions. It's not about the merits of your case, and I think we may not have fully succeeded to steer from talking to the merits, because they're intertwined with your processes, your thought processes, your decision-making process, what you evaluated, and we compare that with the legislative mandate that you have and requirements. So fact that there will be reviews and representations that maybe do succeed is not really of our concern. Our concern is, how do you make this charge, for example, how does that allegation even arise that she is potentially guilty of a predicate offense of gratification? But not just her. And she has been the focus of Commissioner Khumalo because she's a civilian. But any criticism that comes out of Section 25.3, in my view, applies to everyone that you have charged.
We cannot forget the reason IDAC is now under the spotlight. Lieutenant General Nhlanhla Mkhwanazi named it at the July 6 media conference last year. Mkhwanazi alleged that the criminal case against crime intelligence head Lieutenant General Khumalo and others was not a bona fide anti-corruption investigation, but was designed to remove him from office and derail sensitive organized crime investigations. He also alleged that there was an informal network operating between suspended crime intelligence deputy head Major General Firoz Khan and certain IDAC officials. According to Mkhwanazi, this network influenced investigations and criminal cases involving crime intelligence. He further alleged that arresting the national head of crime intelligence was intended to interfere with ongoing investigations into organized crime. So when one hears the lengths to which IDAC went to charge Khumalo and others, the question arises, were Mkhwanazi's allegations really that far-fetched? Andrea Johnson is scheduled to be back on Monday when the probing will continue. If you enjoyed this episode, please don't forget to like, comment, and share it. And for this channel to grow, I need all of you who are not yet subscribers to please consider doing so. That was another episode of Joe Talks Politics. And from me, Joseph Musia. See you in the next one.